Hello, my name is Peter Bricks. I'm a debtor bankruptcy attorney with offices in Atlanta, Jonesboro, and Cumming. Uh, I'm going to talk to you about liens in bankruptcy today, but first let's get started with this disclaimer. We are a debt relief agency proudly assisting consumers in filing bankruptcy. However, there is no attorney-client relationship with the viewer of this message unless there is a fee agreement. We would have to meet with you individually to offer you applicable and accurate legal advice. This information is intended only for educational purposes. We're talking about liens in bankruptcy, and the easiest way to get started is to define the three types of liens. The liens can be either consensual, statutory, or judgment. Consensual lien, that is where you voluntarily grant a lien to a creditor. Well, why would you do that? Well, most typical example is a mortgage. The lender gives you money in exchange for helping you purchase the property. They want to make sure you're not going to default. They are what's called a secured creditor. You voluntarily give them a lien on your property. If you were to not give them a lien, they would probably not give you the money. So that is a consensual lien. Now there's a statutory lien. That is a lien that arises by statute where a creditor doesn't actually have to sue you to get the lien. You default and they can simply place the lien. They have special power. That could be your property tax lien, that could be your IRS or your State Department of Revenue lien for unpaid income taxes. Homeowners associations can have those liens. So essentially, you missed your payment and now there's a lien on your property. That's a statutory lien. And then there's the third kind of lien, which is a judgment lien. That's one where you were really typical examples: you're sued by a credit card, you're sued by American Express, you defaulted on your credit card bill, they sued you, took you to court, actually got a judgment. Now, to help incentivize you to pay the judgment, they've recorded a lien on your property. So those are the liens that arise. And now, how do you treat them in bankruptcy? Well, a consensual lien, you in Chapter 7 cannot avoid. So you have a first mortgage on your residence, that is a consensual lien. Second mortgage, that is a consensual lien. You cannot avoid them in Chapter 7 bankruptcy. Now, it is a little different in Chapter 13, where you have a first and second mortgage. Even though the second mortgage is a consensual lien, you actually can avoid it through a process called lien stripping. That's in Chapter 13. If your first mortgage exceeds the value of your property, your second mortgage then is deemed entirely unsecured. You can avoid it in bankruptcy. It's actually called stripping it. Now you have to make it to the end of your Chapter 13. Your discharge is going to be, the stripping of the lien will actually be contingent upon achieving the discharge. But you can do it in that scenario. Then there is a statutory lien. How are those treated in bankruptcy? Basically, Chapter 7, Chapter 13, you're not going to be able to wipe those out. In Chapter 7, you're just going to be stuck with the lien. You might not care. You might be vacating the property. So the HOA might have placed the lien on your home. Your property's worth $60,000, you owe $100,000, you're really surrendering the property. The HOA lien it's statutory, it's on the books, but you don't care. So the extent you care could vary. In Chapter 13, you are, typically if it's tax debt, it would depend. Is it property tax debt? Is it tied to a property you're keeping? If so, you're going to have to pay it off. Is it income tax debt? If so, you're going to presumably pay off the lien, but that could depend on a variety of factors. Your final kind of lien is your judgment lien. You have a judgment lien, like we talked about with American Express getting a judgment. Can you avoid it in bankruptcy? Chapter 7, yes. There is a provision, the code sections 522F, that is where you can avoid a judgment lien in bankruptcy. So now it's going to depend on the equity situation. It has to be such that it does not, that it does impair your exemptions. So if you had so much equity, say in your residence, that the lien, even though it is a judgment lien sitting there, it's not impairing your exemption, then it could stay on the books. For the most part, obviously with underwater properties, judgment liens are not, they are impairing your exemptions and they are avoidable. So typically in Chapter 7, if you've got a judgment lien, your attorney is going to file what's called a motion to avoid lien and is going to be successful. Chapter 13, you also can file that motion to avoid lien on those judgment liens, essentially move them over to the unsecured pool, assuming the same rule applies. It's impairing an exemption. Of course, fact specific, that might not be all that important because maybe you're paying your unsecureds 100 cents on the dollar. So you're just moving it from one pot to the next pot. You're not really changing your repayment plan. So that is liens in bankruptcy.